You make a nice point that juror bias requires something more than just suspicion, if you will, or conjecture or speculation. And that fact standing alone, that she thought the Frisbee family was a good family, is kind of vague and kind of amorphous. You have to layer that in with the other facts of the case, including the electronic communication in the middle of the trial, and including her view, I guess, before trial, she thought she was not likely to sit because she knew the family.
Well, I think that just shows that she didn't have a full understanding of the legal process. She thought simply because I'm familiar with this family, I will not make it on the jury. So she wasn't aware that she could be rehabilitated, that they could ask, nevertheless, can you be a fair and impartial juror? So she simply did not understand the process, which also supports her statement that I didn't know how to volunteer this information. Now, in terms of looking at his entire situation, there are additional facts that show she did not have certain willingness to convict the defendant. She was not partial against him, excuse me. In the judge's chambers, when she was asked about this family, she stated that there would be no winners in this situation. She didn't consider a conviction a win. She broke down in tears after the verdict because she felt so awful about sending a father to prison. She was so distraught over the verdict that her daughter called her, and that's at the point that her daughter said, "No, I think you reached the right verdict. The victim is known to be a sweet guy, and the defendant was known to be a whack job." She further tried to ease her nerves by researching Doug Knight's age after the verdict to kind of ensure herself that Doug Knight was not a viable alternative to the defendant killing Buddy Frisbee. And lastly...
Well, what do you make of the post-verdict communication with the mother that I'm willing to talk to you about the verdict? It's too bad it wasn't murder one, but I'm paraphrasing, not very accurately. But as you know, there was the commentary after trial. She comes back to the mom and wants to talk to her about it.
Is it okay if I go over my time?
You may.
Okay, thank you. So there was 2 Facebook posts after trial. There was the juror who had her own post, and in that she supported the verdict. She stated, "I have never been a juror and never seen an actual trial. I did not realize what it entailed until this last week." And further, she states, "There are no winners in this. People are still hurting because of this, but I feel that justice had to prevail and the system worked." Now, in terms of the statement of the first-degree murder, Renee Frisbee had posted about the verdict being for second-degree murder and that she was hoping for first, but that they would take it. And Ms. Griffin simply said, "I wish you could have gotten murder in first degree. I can safely say that this
Why does she wish she got it? I wish she got it. I'm having trouble with that. In more ways than one. I wish that she could have gotten first-degree murder. What does that reflect on the juror's state of mind?
I think she's just sympathizing with, again, a mourning mother. She understands that receiving the highest punishment would be the best result in Renee's eyes. But she does go on to say that this was a very hard decision and that she could explain it to her at some time if she would prefer that. So again, she's standing by the jury's decision. So she herself was not out to receive this first-degree murder. She stood by the jury's verdict. Thank you.
Thank you, Ms. Mapes. Ms. Regenold, may proceed on behalf of Mr. Webster.
May it please the court. Counsel. I am Regenold of the Appellate Defender Office, here on behalf of Tyler Webster. The Court of Appeals properly held that Webster is entitled to a new trial. Error was preserved in this case on both the bias and jury misconduct issues. There's no dispute about what took place or what did not take place at jury selection. And trial counsel asked all pertinent questions of the juror in chambers. He asked her if she knew either of these families, how she knew them, how long she'd known them, the nature of their relationships, and if the nature of those relationships would affect her in any way or prevent her from deciding the case based on the evidence, and if she was biased. Based on all of these things, trial counsel passed for cause. based on her responses.
Yeah, I've looked at that testimony, and it seems to me the juror was not dishonest in her responses, maybe a little guarded. You know, she didn't talk on at length, but the question, your counsel asked questions, she responded about how she knew the Frisbee family and so forth. And it almost seemed like counsel wanted her on the jury. The examination wasn't lengthy, accepted the responses. There was no clear lie. So how do you get relief under those state of facts?
I would disagree, Your Honor, that there was no clear lie in the fact that she said that she hadn't formed any opinions about the case that were based on the evidence.
And why do you say that was a lie at that time?
Because she had formed opinions about the character of Buddy Frisbee and Tyler Webster. And character was a crucial issue in this case because this was a case of justification. And so we have to look at the character of those two individuals and
What makes you think she formed opinions of the character of the individuals? There is some testimony in the record about the Frisbee family being a good family and so forth. That's kind of a general observation. What in the record supports the view that she had a preconceived notion of these two individuals?
the information that she conveyed at the hearing post-trial, Your Honor, where she referred to my client as a whack job and a verbally aggressive, mouthy person, and the victim, Buddy Frisbee, as the nicest, kindest boy.
But that's after she's heard the evidence of trial. I mean, jurors form opinions about defendants after they've heard the case, right?
Yes, Your Honor, but there was no evidence at trial that Buddy Frisbee was the nicest, kindest boy. The evidence at trial was to the contrary.
Well, there was, and certainly there was substantial evidence that your client very unnecessarily went and got a gun and shot him twice in the head, right?
I would disagree with the adjective unnecessarily, Your Honor.
But I mean, his defense was that it was necessary, but there was certainly evidence that it was unnecessary. But let me push back to a thought experiment. I mean, to find for you, don't we have to find that if this juror had been challenged for cause, this juror who, there's no dispute, she did not know the victim or the defendant, for that matter, before trial. She didn't. I mean, she didn't have some knowledge of the families. And she said she could be fair. If someone in those circumstances had been challenged for cause, and the court had said, no, I'm not going to grant your challenge for cause, then I'll be saying, in effect, the court abused its discretion by not excusing the juror under those circumstances. Isn't that the thought experiment? Because isn't that kind of what your appeal boils down to? That there should have been a challenge for cause made, and if it had been made, it would have been an abuse of discretion to deny it, right?
No, Your Honor, that is not my argument. I do not believe there was a challenge for cause based on what Susan Griffin said in chambers. Because nothing she said rose to the level of a challenge for cause. She was not related. She was not invested or had an interest in the outcome of the case.
Then how do we then get from that situation to, because things were said after the trial and there was this one like of something the mother said on, the victim said on Facebook, we get from when we add those in, now all of a sudden we get a reversal on the new trial. What does that add to your argument? That's where I'm having trouble.
I think I'm a little confused about your question, but my point is that there was no challenge for cause at the time in chambers. Counsel had no reason, based on her responses and his knowledge of her, based on her responses and anything that came out during voir dire, he had no basis for challenge for cause. It's what came out afterwards, the misconduct, the various...
But at the time when they were in chambers, all his peremptory strikes were gone.
Correct.
And the problem was that there was no way to get him off. I'm sorry, to get her off at that time with their peremptory strike, because he had no other way to get her off. And you may be right, there was no challenge for cause at the time based upon her answer. But by her withholding this information, so that time, your defendant lost a peremptory strike he may have used. And that sort of bothers him to me.
Yes, he lost the chance to exercise a peremptory strike because they were gone at that point. But it wasn't until later that anything that rose to the level of challenge for cause came out. It wasn't until post-trial that we learned about the opinions that she has.
Do we know that if the information that came out in Chambers came out in Bordier, that he would have, the counsel would have exercised a peremptory strike?
We don't know that from the record, Your Honor.
Counsel, is it your position just taking the Facebook contact by itself, is that enough to, in your view, grant a new trial?
I believe
And if so, why?
I believe any one of these allegations of misconduct would be enough. And the state, on its initial argument, commented that the juror wasn't aware or didn't believe that clicking a like would be communication. I disagree with that because when she was in Chambers, they talked about Facebook. She acknowledged she's friends with the Frisbee family on Facebook, and she's acknowledged, I know I'm not supposed to be reading anything on there. I know I'm not supposed to do that. So she was aware of the admonition. She was aware she wasn't supposed to have contact.
Well, but the Facebook comment that she liked was, give me strength, and it wasn't a particular view of the trial. I mean, here's a mother who's going through a terrible event. She puts on her Facebook, give me strength, and it's light. I mean, it's not expressing a substantive view of the trial.
No, but it's affirmative support of the victim, and with the example Justice Wiggins gave earlier, if I'm representing the defendant and during a break in the trial a juror goes to hug or pat the victim's mother on the shoulder, I'm going to be concerned.
Let me back up. I mean, you've talked about withholding information. Is there any evidence that this juror answered untruthfully to any question that was put to her, either at Bordier or at any other time?
I believe she was not truthful about her having formed opinions or having a relationship that would prevent her from deciding this case.
But that's kind of an opinion area. Is there anything factually where she gave an incorrect answer?
When she was in Chambers?
In Chambers or Bordier, I understand Bordier wasn't reported, but there were representations made about what happened and didn't happen there. And her version was, I wasn't asked the right questions. If I had been asked these questions, I would have given the information that came out wrong.
Well, I think that's not completely accurate as far as maybe she was not asked. You're right. No one was asked during Bordier about whether they knew the families. They were given a list of people that were presumably going to appear at trial as witnesses, which none of the Frisbee family were listed as witnesses. But we also know that during Bordier, one gentleman stood up and said, I know the Frisbee family, I know the Webster family,
Oh,
I should serve on this
But
case.
I mean, I doubt that there's an affirmative duty of a juror to get up and make declarations absent a direct question.
I'm not saying there's an affirmative duty, but she observed that. And we also know that before trial, she told the clerk of court and the assistant clerk that she should not serve on this jury, or she wouldn't because of her relationship to a family. And she said that to a fellow juror as well.
As we know, she's not a legal expert. She doesn't know what the standards are for jury service.
No, but she's also an employee in the courthouse, albeit with the DOT. But
She works on driver's license.
Yes.
She's not a legal.
I'm not saying she's a legal expert in any way, but someone who works in the courthouse has a little more familiarity than your average juror off the street.
And your point is, if the other juror stood up and revealed, without prompting, his relationships, that should have given her both the knowledge and the understanding that she has the ability to do it as well, right?
Yes, Your Honor.
Why shouldn't we defer to the trial judge who sees her firsthand, who watches her, hears her voice inflection? Isn't he in a better position to decide whether she's truthful about whether any of these communications were improper or influenced her?
Your Honor, he was the one who heard this, but I think he also did not consider the differences between what she revealed in Chambers and what was revealed at the hearing. In addition, I think it's important to note that this juror listened to what everyone else said at this hearing post-trial, because we know that she referenced the testimony of Karen Taylor and the testimony of Ann Webster in her own testimony. So she's already sat there and heard what the witnesses have said that she has done or not done that was improper. And at this point, She knows there's something wrong. Even if you're not a legal expert, even if you don't work in the courthouse, being called as a juror to come back and testify before the judge and be questioned, you know there's something wrong, that they believe you've done something wrong at this point. And no juror, as Justice Marshall pointed out in a dissent in the U.S. Supreme Court, no juror at this point is going to admit that they were not impartial, that they did something wrong.
Ms. Regenold,
On the record, that's what I'm struggling with still. We haven't had anything other than mere conjecture or speculation as to what her bias may be or what this misconduct might be. And so, if we're looking for an abuse of discretion, the court looked at all this. He was the person who did all the interviews and talked to us, sat through the Bowie Dyer, did everything else that was involved here, and there was no real problem. Of course she's going to come in and testify as truthfully as she possibly can. Whether you're going to want to admit it or not, I don't think, there's nothing in this record that demonstrates to me that she's going to come in and lie. Whether, in all due respect to Justice Marshall, are you going to feel comfortable doing that? Of course not. But nobody, you think that she just came in and lied and said, oh, well, none of this had any impact on me after the fact, and just lied about it? And what evidence in the record is there to support that conclusion?
She may or may not have lied, Your Honor, but there have been psychological studies that have shown that jurors are not the best people to determine whether they themselves are impartial. Because, as a trial judge, you sat through many jury selections, people want to believe that they are impartial. You can ask them questions. I once had a sex abuse case where the alleged victim was 8 years old. And anytime we mentioned that during the jury selection, one juror would start crying. But she maintained that she could be impartial. Even though I'd say, ma'am, you're crying. You haven't seen this boy yet. You haven't heard any testimony. Oh, no, I can listen to this. We want to believe that as a people. We want to believe we can be good people and hear these things and judge impartially. But some of us cannot.
Well, that sounds like that's a good. Counsel, how much time lapse was there between this interrogation where Ms. Griffin was brought into chambers and interrogated about the relationship, and then the Facebook contact where she liked the stepmother's comment about needing support?
It was on April 11th that Mrs. Frisbee posted "Give Me Strength." I am not aware when the juror would have liked that comment. I know that trial, it was on the very last day of evidence in the trial that the parties brought the juror back into chambers. And so it was on that last day when all the evidence was submitted that they questioned her. The next day would have been when closing arguments and the case was submitted to the jury.
And do we know, does the record reveal with certainty that she liked the comment on Facebook before the jury went into deliberation?
I'm sorry, Your Honor, I don't know that. I do believe from the record we know that it was after the in-chambers discussion that she liked that comment.
Ms. Regenold, my question goes more to our legal standard. The issue isn't so much that there may have or was misconduct in this case, but the legal question is whether or not the misconduct influenced the outcome of the case, influenced the verdict. And then our legal standard is one of abuse of discretion, but we define it as a broad discretion. How is it that we apply that legal standard to the misconduct in this case?
The legal standard is abuse of discretion when deciding a motion for new trial. And whether the ruling was based on grounds that were untenable or unreasonable, which would mean that they were not supported by substantial evidence or based on an erroneous application of the law. And I believe there's not substantial evidence in this case to support the ruling that the district court made.
That the verdict was influenced and because of this misconduct?
Yes, because she had an actual bias. She had well, the Court of Appeals determined that she had an implied, if not an actual bias, that she had a fixed opinion that prevented her from being able to decide the case based on the evidence presented and not her own views on the parties or her connections to the family. And I believe substantial evidence supports a finding of bias and
Okay,
misconduct.
which was a view not shared by the district judge.
Correct.
And so my final question is that our legal standard is to give, not only do we say deference to the person, the judge on the spot, but we give broad discretion.
That's true, Your
Is
Honor.
that, do we need to re-examine our legal standard?
I think it's concerning in a case where this is a motion for new trial and it's abuse of discretion is the standard, but we are talking about a fundamental right to an impartial jury, which
Is
is
it a constitutional issue, or is it just a rule of procedure?
Counsel referred to his due process rights in his motion for new trial, and I believe, or at least in the hearing, he referred to that.
How about the Court of Appeals? Does it rule on constitutional claim? I mean, arguably a constitutional claim, you get de novo factual review, but if it's not a constitutional claim, maybe not.
They referenced the right to an impartial jury. I don't believe they ever referenced whether it was de novo review or not.
So is the due process claim alive or not?
It was not decided by the Court of Appeals, Your Honor. And I would also remind the Court that this was raised under ineffective assistance as well. Thank you. We would ask the Court to affirm the decision of the Court of Appeals.
Thank you as well, counsel. Ms. Mays, you may give your rebuttal argument.
I'd like to jump to the question that you had asked Ms. Regenold about what facts were false in terms of Ms. Griffin's disclosure in the chambers. And the only thing she pointed to was that maybe Ms. Griffin had a preformed opinion. However, the information she cited, the statements about the defendant being a whack job, the statements about Buddy Frisbee being a good boy, was all information Ms. Griffin obtained after trial. It was from the phone call she had with her daughter after the verdict came down. So that was not even information or an opinion that she held during trial. So that certainly can't be used to discredit anything she said in the judge's chambers. And in terms of what she acknowledged in that meeting about going on Facebook, she did say, I know I'm not supposed to be doing that, but that was in reference to reading things specifically about trial.
Can we reach all the issues in this case, or do we have to reserve some for post-conviction relief? Because I'm concerned that, that in trial conversation between the juror and defense attorney, I don't think it would be for cause. I don't think so right now. But you've taken away a peremptory challenge that you may want to make if you knew that information before trial. And, I mean, don't we have to see what he was thinking when he was doing this and why he did or didn't do it? I mean, to dispose of this case, I mean, I think if we came down and said there was no prejudice or no bias, we rule out that evidence. Can we take care of the whole case at this point, or do we have to reserve something?
We can take care of it at this point. And in terms of the claim of ineffective assistance that was raised, that was also raised specifically in terms of the juror misconduct claim. Since they did not raise a standalone claim of bias, the claim of ineffective assistance counsel doesn't attach to the bias claim, only the misconduct claim.
But can we reach that claim, though? Because we don't know what was going through the attorney's head when he was faced with the situation. I don't know the challenge for cause, but I can't get rid of him now. I mean, isn't that important?
If we're looking at bias, to show prejudice, the defendant would have to establish actual bias, that the juror was in fact unable to be impartial.
Well, aren't you biased if you don't have a peremptory challenge to get rid of somebody who you can't get rid of for cause, but you can get rid of on a peremptory? Isn't that, aren't you, treated unfairly as a defendant because you don't have that opportunity?
He's not, because there's no evidence that this juror sitting on the trial had any impact on him. That's why we would have to look at whether actual bias existed, because otherwise Ms. Griffin sitting on this trial did not prejudice the defendant.
I've tried hundreds and hundreds of cases, and I've never left anybody on the jury who knew one of the parties for various reasons. And there was never a way to get them off the cause. You always had to use a preference. That was gone in this case. Isn't that important?
It's not, because again, we're looking at whether Ms. Griffin could be impartial, and that's why we look to see if there's actual bias. And so without there being evidence of actual bias, even if he would have preferred to remove her with peremptory strike, he still was not prejudiced in this instance.
So you think a juror can be unbiased even though they think that they're not qualified to sit in the jury, they defy a court's instruction to build a trial and communicate by Facebook, and then at the end of the trial, on the very first grade, communicate that we would have been first degree murder. But that's not enough to demonstrate actual bias to you.
It's not, Your Honor. In terms of her thinking that she wasn't qualified, many times people volunteer information, think I shouldn't sit on this for whatever reasons. They're asked follow-up questions, and if they can say, okay, yes, I can be impartial.
Well, I think jurors do not say, I'm biased. They don't, I guess they can, but it's pretty rare. We don't find it in the case books. It doesn't get reported. I guess if jurors declare their bias, it's thrown off immediately. But by and large, human nature says you don't step forward and say, I can't sit. So we have to make inferences based on evidence, and I think your point's well taken. It's got to be real evidence and not conjecture, not speculation, and all this kind of thing. But we do have some elements of real evidence that individually might not mean much, but collectively, do we really have confidence that this juror was qualified to sit on?
We do, because if we look
Other than
at...
the self-expression of beyond qualified, obviously.
Correct. And we do look at the conduct and the statements that a juror makes to see if we can find bias based on those. But if we separate this out, there's a lot of information in this case, and some of it occurred during trial, but a lot of it did come out after trial. And so we have to look at the timing of these things. And in terms of what happened during trial, yes, she went on Facebook. That was imprudent of her. It was in violation of the admonition. But that did not show misconduct, and it doesn't show bias if we look at what that status actually said and what she did. And the only other conduct that happened during trial was the Locally convenience store incident, and that was not attributable to her. It was other people trying to have a conversation that she effectively avoided.
Is the state's, what's the state's position on whether there's a constitutional due process claim for us to decide at this point?
The defendant certainly hasn't raised that claim. I believe in both of our briefs we have addressed just standard review as abuse of discretion. And so, no, he has not asserted a due process claim.
In view of the broad trial court discretion, if the trial judge had granted a new trial, would you be in front of us arguing that was error, or would you say that was within his discretion on this record?
We would probably be up here challenging it because the record doesn't have substantial evidence of bias, but there was substantial evidence to support his finding that there was no misconduct and there was no bias in this instance. Thank you. We ask you to reverse the Court of Appeals decision and affirm the conviction.
Thank you, counsel. The case of State of Iowa versus Tyler James Webster is now then submitted.